Hey everybody, what's up? Welcome to this Vice News live stream. I'm Todd Zwillick, Deputy DC Bureau Chief for Vice News. And today we're going to talk about the 9 justices of the United States Supreme Court. You know, in an increasingly fractured country, in an era where traditions like deference to police and honoring Confederate racists are giving way to progress, and old norms like advice and consent and the independent judicial system, those are groaning under the heels of corruption and authoritarianism. Americans still feel like those 9 justices are kind of a last refuge of sober and considered, if not apolitical, at least not anti-intellectual governance in this riven nation of ours. So what I'm saying is that in these unsettling times, in these difficult times, in these uncertain times, the Supreme Court is having a moment. And as this spring term of the COVID court draws to a close, none of the 9 justices is having a bigger moment than Chief Justice John Roberts. Roberts is a conservative. He was elevated to Chief Justice in 2005 by President George W. Bush at the judiciously very tender age of just 50 years old. Now, Roberts' job isn't just to rule on cases, but it's also to steer the court, to protect its standing and its reputation in American life. And lately, well, John Roberts has been pissing off a lot of fellow conservatives. Within just the last couple of weeks, John Roberts has voted with the liberals on the court to slap back the Trump administration on DACA, to overturn abortion restrictions in Louisiana, and to recognize equality in the workplace for LGBTQ Americans. So it's a great time to ask, just what is up with John Roberts? Is he hiding a liberal activist under those robes? Is he an uber dignified never Trumper defending the country from a garish president? Or, as my guest says, is he playing a much, much longer game? One that gets a lot more complicated once eventually the viruses and maybe even the authoritarianism begin to wane in this country. Kimberly West Falcon is a professor of law. She teaches constitutional law at Loyola Law School in Los Angeles. She's a graduate of Yale Law School. She's a former civil rights attorney and a former clerk in the Ninth Circuit Court of Appeals, President Trump's least favorite circuit. Professor, thanks for being here.
Hi there. Thanks for having me, Todd.
And am I right that the Ninth Circuit is Donald Trump's least favorite circuit? Probably.
Well, the Trump administration and Mitch McConnell have managed to appoint so many federal judges. I don't know if you can say there's a least favorite anywhere for them anymore. The Ninth Circuit
Not
is
anymore.
quite a bit.
I saw,
Anymore.
we can talk about this a little bit, but Mitch McConnell was crowing the other day that Republicans and President Trump have approved 200 judges to the federal judiciary now, and that now for the first time in 4 or 5 decades, the circuit courts, the appellate courts, have 0 vacancies. They have really, packed the court's pejorative, but they've really packed the court. This has been a huge success for conservatives.
It's really easy to win when you change the rules of the game. So they have gone, Mitch McConnell has created a new process for affirming federal judges that has made that possible, but it will really have long-term consequences with respect to the meaning of the Constitution and federal statutes for generations to come.
Yeah, well, getting rid of the filibuster will do that. But let's talk about the court. Let's go across the street from the Senate. There on First Street in Washington, D.C. Let's go to the court. We're going to talk about some of the cases in this term for sure, about John Roberts, about some of the politics around these cases. But before we do that, Kimberly, we're still waiting on some opinions from this current court. What's your big takeaway, though, from this term so far? What, in your view, in the COVID summer of 2020 has the court been up to?
Well, that's a question I am so excited to dig into. And I want to say first off, the couple of things about me that you already know this. I'm a geek when it comes to constitutional law. So I'm excited about having this conversation. The idea that I get to just talk about con law, even like have homework. And I was like, oh, because I made myself homework. And I was like, I have notes. So if you see me looking to the side, it's like, okay, well, what was the justice count on that one? Because it is a mind-boggling term, and we have so many important decisions that have yet to be decided. And it is running so late into the summer not to mention COVID, not to mention the protesting over Black Lives Matter and things of that sort. So it is really hard to even stay focused on the court as much as that's what I'm truly into. So I do have some thoughts about what has happened so far. I mean, there's absolutely no question that the Title VII employment discrimination case conferring those civil rights to LGBTQ persons is transformative. I mean, that is a momentous decision. The decision for deferred action for childhood arrivals, also momentous, and momentous in the sense of how it affects people's actual day-to-day lives. So those opinions and lots of other ones are truly significant. I also think that some things that are going on with respect to the religion clauses are very notable, and we're going to be looking back on that moment from now. But your question that is the most provocative to me is the question about what's going on under, oh, wait, we don't even know what's going on under his robes, but what's going on in the head of Chief Justice
What is
Roberts.
going on under those
That got a little
robes?
untoward, right? Yeah, let's just stick with what's going on in his head. But what I do not think it is at all possible that Chief Justice Roberts is hiding a progressive ideological stent. That
He's
this is
not a secret
definitely,
liberal, in other words.
he is not a secret liberal. I love that you boiled that down. So I think instead he is an activist seeking to change the meaning of the Constitution in ways that, again, will be transformative for decades. So I do think he is playing a long game for sure.
All right, now somebody hears you say that, Kimberly. John Roberts is not a secret liberal, and then they look back in the very recent opinions of the court. They say John Roberts slaps down Donald Trump when it comes to deferred action on childhood arrivals on the DACA program. John Roberts rules with the liberals when it comes to LGBTQ rights in the workplace. John Roberts rules with the liberals and strikes down, unbelievably, abortion restrictions in Louisiana. But you say no, that's not liberal. You say he's up to something else.
Yeah, so I will also concede that I sometimes dub myself when I'm teaching constitutional law a Debbie Downer. I will concede that I have the capacity to grab defeat from the jaws of victory. I can do that, right? That is a way you can interpret
Great.
virtually everything I say. But it is also true that if you really want to understand uh, and evaluate the extent to which a justice of the Supreme Court is a principled decision maker. You don't just read the individual decision because they're smart folks. They are trained. They have great clerks who are very trained. Individual legal decisions should read well. They should be persuasive. In fact, my students experience that too. You read the majority opinion, you're like, wow, I'm persuaded. Then you read the dissent, oh, now I'm persuaded by them. So the reality is that for the average person, you're not going to be connecting all the dots of John Roberts over time. But John Roberts over time is someone, we don't have to even go that far in the past. He upheld President Trump's travel ban that, even us calling that when President Trump was willing to call it a Muslim ban. So in any one of these areas, if we look with greater detail, there is the fact that I would say what is driving John Roberts, I think, and that was what was good about having this conversation. Let me think about what's driving John Roberts. I
Mm-hmm.
think he is interested in preserving his own power, which who wouldn't want to? If you're on the Supreme Court, it's a very powerful position. The power of the Supreme Court, which is the institutional power, and I think every one of those decisions, when you dig into the details, and I'd be happy to geek out on that and go through some of those, that you can see how they relate to that bigger goal. I think the way to respond to the interesting idea that he could be a secret liberal is to really, though, take him for his word and take him for what he has said in these opinions. That every one of those decisions is decided on a narrow grounds, is decided in a way that doesn't change his overarching approach to interpreting statutes or the Constitution. And, what I did, but he is still anti abortion, anti voting rights, anti affirmative action, anti-same-sex marriage, set on expanding gun rights, set on limiting Congress's power. He sees religious rights as more important than race discrimination rights or gender rights. So the devil is really in the details when I think it comes to Chief Justice Roberts.
All right, well, let's look at the Louisiana abortion case that just came down to get at that a little bit. Because if you just kind of read a headline, or if you skirt by that story as you're browsing, you say Roberts deciding vote, Supreme Court strikes down abortion restrictions from the conservative South, and you say, boy, sounds like a secret liberal to me. There was just somebody on my Fox News yelling at John Roberts for being a secret liberal. But when you read the opinion, and you're the expert on this, but when you read the opinion, John Roberts wasn't really talking about abortion at all. John Roberts was talking about, there was another law next door in Texas that was almost exactly like this one. We already decided that one, and this court is going to obey precedent. So he's asking everybody to sort of get abortion out of their minds. And I, as a non-expert, I get that, but then I think, God, there's so many before you have found ways to get around those quaint, those quaint fealty to precedent. But John Roberts says no, and he strikes down a law that a lot of conservatives really wanted in the abortion wars.
And so before I again enjoy and will love to geek out over June medical services, which is the abortion case, I do want to credit and take seriously, well, what's going on then? Why is he voting the way he's voting? And so the other observation I would make about Roberts and trying to think about what's going on, I think he is trying to be the moderating presence amongst a group of justices who have now gotten the power to do virtually anything they want. I mean, there is precedent and there is the principle of stare decisis, but it's a judge-made principle that they have to adhere to prior precedent, and it is baked into the principle of stare decisis that there are factors judges should consider to decide when they are going to overrule prior cases. And the reality is, just because the Supreme Court is final, this is me cribbing from a famous justice, doesn't mean they're always correct. And I'm paraphrasing as well as cribbing. So the Supreme Court has been wrong. I mean, they were wrong in Plessy versus Ferguson. The Equal Protection Clause does not permit Jim Crow segregation as I think it is properly interpreted, so you overturn it. So you're absolutely right that there is some room to make those decisions. So why has Roberts, in cases about the constitutionality of the Affordable Care Act, in cases about DACA, in cases where people are looking, and I think that may be a way to think about this, is that when the public is focused on a case and when the outcome would lead to negative feedback for the court and Roberts and even my law students, because it's something we teach constitutional law students quite regularly, we have a precedent in the 1930s of a Supreme Court that got too far ahead of public opinion and then got put back in its place. And it got put back in its place in ways, as I was thinking about it before our talk, that could be a lot of similarities. That court was the court that got put in its place by a Democratic president that had a Democratic Congress. So that was FDR passing New Deal legislation. The bulk of Americans, the 99 percenters, suffering in bad economic times, and a Supreme Court that was ruling for the robber barons, the monopolists, the 1 percenters or the 0.01 percenters. And so there are a lot of similarities between this current court majority and how their outcomes. They have a lot of outcomes that lay people aren't watching that are really helping the 1% or the 0.01% or the powerful, as opposed to those lacking power. And so I think Roberts plays enough of a long game that he doesn't want to repeat those historical errors, right? He wants to accomplish his changing, and I say it's going to be a radically different interpretation of the Constitution when the John Roberts Court gets written about in history, but he only gets to do that if he avoids being, and the court avoids being Icarus flying too close to the sun. And I think you've got other justices like Thomas, and Kavanaugh even, that aren't that concerned. Thomas has been dissenting and complaining and saying he would overturn and ignore every precedent since virtually he got on the court. And it doesn't matter if you're that lone guy dissenting. But when you have 5 votes, without the moderating presence of John Roberts, you could have an American public, mostly sheltered in their homes, waking up and seeing people who have lived in this country their whole lives being shipped out in some unimaginable way. Can you imagine what would be on our phones, what people would be in the streets about? Can you imagine if John Roberts just came out directly and said, today we'd like to overturn Roe v. Wade? Again, there'd be a lot of pushback. And so I think the subtlety and the strategy with which he is operating is ultimately helping those justices like Justice Thomas who want to get to a very different rule of law, to do it in a way that I think also fits his institutionalist style. I also think he cares about the rule of law, but I think we're going to see when these last decisions come down, because that's the other thing. What is he going to do about executive power? What is he going to do about these rule of law decisions? And maybe that's where there's some wiggle room. So that was not an answer to the abortion case question, which again I'd love to delve into, but let me just pause there. And we
Yeah.
said we were going to kind of chat. So any
Yeah,
so should I
it's
go
super
back to
interesting
abortion,
because
or what do you think?
well, no, I think it's super interesting when you talk about Robert's sort of his method of steering the court, because the political school of court watchers, which is where I come from, looks at Roberts and says, well, what he's trying to do is he's trying to save conservatism from the Republican Party right now. Like the Republican Party has left conservatism. It's become sort of a populist white grievance based party with Donald Trump's base. That's not where John Roberts comes from, though he is a conservative, and he sees the current republicanism driving the party to places where the public just isn't anymore. For instance, the public, in many ways, when it comes to basic rights for LGBTQ people, the right to marry, the right to just be treated like a regular person at work, the public has moved on from this. The public doesn't want to wake up tomorrow on their phone and see 800,000 DACA kids who came here when they were 2, if you like, deported. The polls show, I don't know, 85% of the public is for DACA. The Republican Party has gone to a place where they're getting in front of the court and arguing to do these things. They're arguing to treat gay people differently at work. They're arguing, yes, to give the president the power to deport these young people. That's so far from where the public is. The political school says, well, Roberts understands that republicanism has gone a long way from conservatism, and he's doing what he can in a fractured culture to save the Republican Party and save conservatism from itself. That's sort of the political school, and that's nakedly political. But do you buy it?
Well, it's not my analysis as the constitutional law expert goes immediately to cases that run counter to that. But let me back up from it, because this is more of a political, either political or, I guess some of it's constitutional law. But it's I am old enough to remember when we had conservatives who supported their outcomes, in judicial conservatives who supported their outcomes by saying, if we do it this way, we're maintaining the status quo. We're not engaged in change. I mean, Chief Justice Rehnquist, when he was a clerk and saying that Plessy versus Ferguson should be upheld, that's kind of the way his memo to his judge operated. And that would have been the true of Bork when he was going down to the court. There was a way in which conservatives and conservative judges could say, we're non-activists. And, I don't know if you can remember, but that was the critique of the Earl Warren court, that, hey, you guys are overturning things, changing the world. We conservatives are constrained. We don't use judge-made power. We're not big on accumulating power for judges. We don't do judge-made law. We leave it to the people. We leave it to the states. That's
Mm-hmm.
where I have, in the last probably decade, taken issue with the label of conservative for any of the current Republican appointed judges. And Clint Bollock, he's, an activist in that realm. He wrote a book long ago saying, trash that whole idea. Now that we are in charge of the courts, conservatism, if it means keeping things the same, is the past. And there has been, within the Federalist Society and all of the judges we were talking about earlier been appointed, a real embrace of activism. And so I think that Chief Justice Roberts is, in that sense, not interested in preserving the status quo. He has interpretations of various provisions of the Constitution that are different from what the law is now. Obergefell versus Hodges, the same-sex marriage case, he dissented. He likened that to Dred Scott or Lochner or some of our counter precedent cases. He hasn't changed that. And he is opposed to interpreting. He says in the June Medical Services case, the case just decided a few days ago about the abortion regulation in Louisiana, that he still believes that laws like that are constitutional. And so saying that explicitly, and this being a 4-1-4 decision, right? You've got only 4 justices and a plurality opinion that are agreeing that the law is unconstitutional. Roberts himself is saying, well, 4 years ago, when the exact same law was before me, I thought it was okay. I was okay with Texas shutting down virtually every abortion clinic. And that is not the status quo when you have a court that decided Roe v. Wade. In Roe v. Wade, the court said there's a fundamental right for women to control their reproductive freedom pre-viability. There's not an absolute right to terminate a pregnancy. Please don't get confused. The only absolute right this Chief Justice might move us towards would be in the context of the Second Amendment, right? Like the way to, I think, see whether someone is principled, whether or not a justice is constrained, and ultimately how status quo focused you are, would be to look at, not just how you vote, but what your reasoning. And I Justice Roberts is. So while he's willing to make these votes, I think the same would be true of the Affordable Care Act case. He's willing to make votes that keep, again, the public from turning on the court, right? He gives us just enough of the facade of, oh, well, I'm just calling the balls and strikes. That's what he said when he was going to be confirmed. But the reality is he is not simply calling balls and strikes, that Roberts, like the other 4 Republican appointed justices, are about to and already taking us on a very wild ride. Again, I'm a con law geek and I love con law, so only I could say that reading cases is a wild ride. But for me, it's a wild ride because I really literally tell my students, if this interpretation of where people get their right to terminate a pregnancy or things like that comes to pass, that big, thick, their con law book is about this thick. It costs like $200. I'm like, you probably should just throw that thing away in a couple of years. Like, if the court goes the way that Roberts has interpreted it, plus the others, now that there's a majority, our heads will spin as to how our rights and what rights are protected with great vehemence, and what rights just are kind of there only on the page. And I think Roberts knows that if he does it the way they did in the 1930s, the people will notice. So there's certain things I just don't think smart chief justices permit, even if you've got 4 guys who are like, yeah, let's tear it all down. I think Roberts is like, no, we do it, brick by brick, and we do it subtly over time. And so I don't think he's, and I think it helps to have more extreme ideologues attacking him, because I think that also
That's interesting
kind of
you say
tells
that
people.
too. That's interesting, the more extreme ideologues attacking him, because in these last few days, like since June Medical, the abortion case, or since the DACA case, certainly since the Title VII LGBTQ workplace rights case, it's pretty hard to miss conservatives online sort of like giving up the pretense about originalism or judges that call balls and strikes. The epithet used to be of activist judges has always been reserved for the Ruth Bader Ginsburgs and the Elena Kagans of the world. We don't want activist judges. We don't want unelected judges making law from the bench. They're not there to do that. And every conservative justice has gone in front of that Senate, and I've been there to watch those confirmation hearings, and said, I will never make law from the bench. And in these last couple of days and weeks, Kimberly, after these Roberts decisions, you've seen conservatives online. I saw Kurt Levy, a conservative legal watcher in Washington, D.C., in the pages of the Washington Post just today or yesterday, dropping all the pretense, saying enough of this 7-dimensional chess of defending precedent here and then not there in the long game. We're sick of this. We need better vetting, and we want conservative judges who rule the right way. We're going to make sure before they get on the court that they're not flipping on us and becoming liberal activists. And like the pretense has fallen away. And it makes me wonder if that's legit criticism, legit anger, like a genuine surprise, maybe an unlettered surprise, if you like, about what John Roberts is really up to, or whether it's a little bit of play acting, whether it's a little bit of pantomime, whether it's a little bit of providing this froth from the right that makes John Roberts actually seem like he's way too centrist for the rightists, and that gives John Roberts a lot of credibility for the future project. You know what I mean? I wonder how
And
sincere that
also
is.
to get out of my area of expertise and to jump back into what you were talking about before, politics. I mean, what comes to mind for me there is if you want more federal judges and you want not just a 5-4 majority, you want a 6-3 majority, then you want people to go to the polls. You want people to understand and vote based on the court. And so it could be, 12-dimensional chess, right? Robert gives them what they want. They scream back at him. It sends people to the courts, and it keeps progressives from voting based on the Supreme Court. It's just enough little bit of raw meat to throw out to progress. And I shouldn't say, I mean, it's momentous to interpret Title VII the way it does. The court has, but that did not change the interpretation of the Constitution. Roberts still is on record of saying he's on record of having voted and given lots and lots of very disturbing analysis. If you are someone who believes in LGBTQ rights, John Roberts does not believe that LGBTQ persons even have the right to marry. He voted and gave extensive analysis that does not violate the Constitution. Why it's a narrower interpretation to say that Title VII, a federal statute, prohibits employment discrimination is that's because that's supposed to be the rule of law. When Congress acts, then the court is supposed to read how Congress acts. So I think that the ruse of conservatism being linked to status quo, we avoid judge-made law, I think that was gone quarter century ago. I mean, I think 25 years they gave up on that. I just think now it's sussing up. There's so many things that right now are going on that I'm like, oh, the nightmares I used to have by myself, or the things that seemed like, oh, she's off her rocker and a conspiracy theorist. One of those things 15 years ago used to be, oh, well, there's going to be a time when the court starts, or there could be a time if things don't change, where the court starts striking down civil rights laws as inconsistent with the Equal Protection Clause or other provisions of the Constitution. Then we get John Roberts voting and writing to strike down the Voting Rights Act. That a lot of the things that academics and theorists have been predicting about where the court was going have really come to pass. And I think now we can have conversations like this one where I can say, yeah, of course, that's actually, if you want to get, again, geeked out, they have a theory of constitutional interpretation that they label originalism. It's called original meaning originalism, but it is a pick and choose version of originalism. I think that if people are together and kind of talking with their friends and family about originalism, you think, oh, that must be an interpretive approach that is constraining. It must be an interpretive approach where the judge cares what the person who wrote the words thought they meant. And then you have to come to law school, pay a bunch of tuition, or maybe hopefully listen to this nice, fun conversation for me to say, oh, no, no, no. That's not actually what their version of originalism was. That's what they want you to think it is, because that sounds very constraining. And no one wants power-hungry judges deciding our lives without any constraints. But what is driving the Title VII case, what is driving a lot of the Republican appointed judges is they say, no, we have a special way of deciding what the words meant at the time, and we interpret them with our own dictionaries, we interpret them with our own clerks. But in a case like Heller versus DC versus Heller, if you read DC versus Heller, Justice Scalia is absolutely rejecting Justice Stevens' analysis that this is what the framers actually intended the words to mean. And that's also what's going on with Title VII in the employment discrimination case of Bostock. that Gorsuch votes the way he does, not because he cares what Congress's purpose was. He doesn't vote the way he does because he cares what the Congress that wrote the words intended. It's because this current, and that's why I say that they're picking and choosing, and it's about their own power to decide. They have both a theory of statutory interpretation and a theory of constitutional interpretation that give them all the discretion. So that
All
can
the
go
leeway,
both
right?
ways, all the leeway. So in Barr,
Hmm.
it's Barton versus Barr, when they're interpreting a statute that means someone who, a Jamaican long-time resident who is here in the country is deported after 25 years from his family. You've got the dissenters in that case. In that case, is Roberts is voting with the Republican appointed judges. The dissenters are saying, here, you're reading this statute in a way that's wholly inconsistent with what Congress intended, but this is the pick and choose statutory approach. So we can pick and choose, and we pick and choose here in a way that Sotomayor is saying this is not at all. This is inconsistent with the text, inconsistent with the structure, inconsistent with common sense. But when we look up one day, that, and I think we're already at that day, we have justices who can give you a smattering of different votes here and there. But ultimately, again, when I try to think about what the theme is, if you get to pick and choose what congressional statutes mean, what provisions of the Constitution mean, you're a very powerful entity in the federal government.
So if you've got a willingness to pick and choose, and I agree with you, by the way, I totally buy that just whatever the ideal is, anybody who's amassed that much power, especially in an era that as riven as this one, they do pick and choose. You might be tempted to see John Roberts say, well, in June Medical, the Louisiana abortion case, I'm going to strike down this law because precedent is important, and this court adheres to the principle of obeying precedent. Super important for the role of the court in society. Okay, then you might think, well, Roe v. Wade is a precedent that was decided in 1973. Everybody wants to know if the court's going to adhere to precedent eventually in the next couple of years when Roe does get challenged somehow. Abortion rights, a woman's right to choose, and a right to privacy under the Constitution. Um, when that comes before the court, does John Roberts saying I adhere to precedent when it comes to abortion in Louisiana mean that John Roberts says I adhere to precedent when Roe gets challenged in a couple of years, or would somebody be like way too Pollyannish to think that?
Well, here's where it's not being Pollyannish, but here's where you take the opportunity. There's so much opportunity to educate yourself and read up and become geeked out at least in one area of law. This is where the long game is involved. That Roe v. Wade is has been virtually overturned. It's been virtually overturned, and the targeted regulation of abortion provisions, all of these trap laws, and I think I may have even said the last the P wrong, but Louisiana and Texas already have five or what you can count the number of abortion clinics and abortion providers on one hand before these laws go into place. So,
By a
the way
thousand
I teach
cuts, in other words.
the death by a thousand cuts. And what I teach my students also is to think about how a state, if you're Texas or Louisiana and you want to pass a law, the way the Constitution works and the way precedent works, you can have a couple of different kind of hurdles. And the highest hurdle was what Roe put in place, that we call it strict scrutiny. And if you were the state of Texas, which happened to be the state in Roe v. Wade, you had to get over the highest hurdle in order to put in a regulation that wasn't going to have any impact if it was pre-viability. Now, post-viability, again, the government can prohibit abortions. But what happened with the case Planned Parenthood versus Casey, which is a 1992 case that really sets the current standard. The standard was already lowered, and it's now something called an undue burden test. And that undue burden test is in the eyes of the beholder, and that's what's
Hmm.
being applied now. So Roberts has no interest in going to the higher test. And there are a lot of areas in constitutional law where you really do have to, again, the devil's in the details, but there's been such a regression, such a change in how the court views where these standards are, that the things that we think people are still fighting over, that battle was long lost. And so what Roberts manages to do is to keep people focused on, well, is he ever going to write the words Roe v. Wade is overruled? Well, you don't need to ever write those words if you
Yeah,
come
it
up
doesn't
with
work like
standards. I
that.
mean, they're moving towards a standard that's rational basis review that's pretty much presumptive constitutionality. And there's language as Roberts is the kind of guy who'll shift the test in a way that only like a law professor trying to teach a law student who had their heads are really, their eyes are about to glaze over, right? Like, what, what's the difference between this and that? It's in the minutia, but that is ultimately, if you want to maintain power, let's go back to the big picture. If you want to keep the public from getting really angry at you, you have everybody thinking you are the you've left the tribe, that you're on their side sometimes, when the reality is it's a debate about whether we'll go from 5 doctors who are performing abortions in Louisiana to 1 or 2 at the most. Now, the big picture is that's a fundamental right in on the page alone, but not one when you implement their tests and standards that women can actually access. And so that's what the long game looks like. And with respect to LGBTQ rights, well, we'll give you the statutory interpretation. And I think there were ways in which in June Medical and Bostock, Roberts was uniquely in a corner, and a corner that I am so grateful he didn't let himself be, isolated in, because there is this principle of stare decisis, and there's supposed to be the rule of law. And let me kind of try and distinguish between those. Rule of law is we can have some faith that when you decide a case, it's going to last longer than a decent sofa, right? Like, think about how long you keep a car, right? Like, this was just 4 years ago. So 2016, and this is what made it uniquely problematic. If you're the chief justice and you vote to strike that law down, the laws are virtually, they're word for word identical. So what you are then telling the world, and Justice Thomas is okay with telling the world that we got 5 votes, we strike it down, we'll do what the people you're describing who are saying, let's avoid the pretense that this is anything other than ideology and politics. But the reality is that's not a smart move if you want to maintain power of the Supreme Court. I'm going back to my story of the old
Hmm.
court. If we the people, if Joe Q. Public really starts to believe you are just members of Congress in robes who have their jobs for life, then when the next president comes in and says, hey, we're still mad about that Merrick Garland thing, can we appoint a new, we're going to pass a law to add a justice to the court, which is it's kind of a tame version of what FDR is proposing. Joe Q. Public is like, sure, they're a bunch of political hacks anyway. They don't believe in the rule
Right.
of law. Their cases change day to day. So Roberts really stood up more for the court and rule of law and maintaining power for the court than he did for abortion rights. That, in my mind, is not a vote, and in my analysis, is not a vote for abortion rights as much as it's a vote for, please still respect us some. Like, how are we going to do this and they'll respect us in the morning, sort of thing. And I feel
Please,
like that really explains him a lot better.
please help. Please keep respecting us, which maintains the power of the court and maintains his primacy. In a lot of ways, Kimberly, it sounds like John Roberts is the Chief Justice, is the guy who's smart enough. This is so pejorative. I almost hate to do this, but I'll do it anyway. The old analogy of the frog in the boiling water, right? You boil it too fast, the frog knows they're being boiled. Uh, Not saying John Roberts is out to boil every frog in America and that we're all his frogs. However,
Yes, I
if
don't
you're
know what that means to me, but I get it.
yeah,
Continue. So, because not all of
yeah,
us know this one, so the frogs are going to stay in there if you raise the temperature kind of slowly, but they'll
yeah.
jump out if it gets too hot too fast. I think that's an excellent
Hmm.
analogy, and I don't think that's exactly what happened with Title VII. I think in Title VII, they were in a different kind of corner because these justices, like I was saying, they have a way of interpreting the Constitution that lets them pick and choose. They are really into this unique version of textualism. And I love the way they name things, right? Like I'm like, the Democratic appointed judges should just be better at naming, right? Because textualism also sounds so constrained. It sounds like, oh, we care about text. And even better than it being, what makes it a great name, and the same with originalism, is it kind of includes in it a dig at the other interpretations. And I'm always telling my students also, there's no judge I've ever met who says, you know what, the way you interpret the provisions of the Constitution or statutes is to never read the text. But the implication by calling myself a textualist is I do something that the other side doesn't do. And that's what you can kind of have that argument. People are like, well, I don't like those judges because they don't care about text. That's not true. So then what is textualism? It is very much, as Gorsuch wrote, and he had written at length. He said, I have a specific way of interpreting the words. And Gorsuch was already on record as saying, I don't interpret the words of a statute. And Scalia had said this already. And precedent was all lined up on the side of ruling in favor of Amy Stevens and Bostock and Zarda. All that was there. But Gorsuch didn't write an opinion about precedent. He didn't write an opinion about, well, when Congress wrote Title VII, its purpose was to make sure that employers don't exclude subjugated groups. I mean, that would have been a really easy opinion, right? Like, I just told you to your face, you're transgender, don't come work for me. You're gay, don't come work for me. That could have been what the words in Bostock were. And you got to be a common law geek to be thinking about, well, what this could have said. And what it said instead was, oh, I get to look at the words because of sex. I get to pull out my dictionaries. I get to use my little step-by-step textualism process. And then I get to tell you what the words mean. And if that is inconsistent with what the people who wrote the words meant, not a problem. And that's why I'm saying looking at the big picture, because Sotomayor is like, but when you look at this immigration statute, you find, they've got that other thing. You find, you're not supposed to find elephants in mouse holes. And, Sotomayor's like, you found an elephant in a mouse hole. This is not, this poor man who had lived his life without criminal violation here in the country. And there's no reason that Congress didn't mean for him to be deported. And so you deport him. And that has implications for a lot of long-term residents in this country. But again, we go back to Roberts. I love we don't want the water to boil too fast, but DACA would be the boiling too fast, right? Because it's very visual. Even going to religion cases, the case where it was the American Legion and there was that big concrete cross in the middle of the road, I was like, nobody's going to want to tear down that cross. Can you imagine what Joe Q Public and all of us are, we're all going to tune in on our phones or something. They're tearing down a really big cross and the Supreme Court told them to do it today. Like, let's all watch the bulldozer. I mean, there's some visual images that courts, institutional chief justices who want the court to survive past them, aren't in the interest of the court. And I feel like that's how the Affordable Care Act case was. I think people would have gone back out in the streets. People were already out in the streets. You rule differently on
taking away their health care all at once. Yeah.
But even with Title VII, right? Like, don't you think the people were already in the streets? There is a coalition between people who care about civil rights and just not murdering Black people, and people who care about LGBTQ rights. I mean, if Bostock had gone the other way, and it had been, and the court had been willing, so I feel like that explains Roberts' vote. I feel like Roberts gave us the Chief Justice institutionalist vote, and Gorsuch was just in a corner. I mean, he's literally got published books about this is the way I interpret text. So I was braced for him somehow saying, and he did. I mean, like there were in that oral argument a lot of talk about bathrooms. Like I was like, well, we could just get, there's a way we interpret text, but if it means that men have to be in women's rooms, we don't do it anymore. I mean, they could have written that, but he didn't. But I don't think he should get, now I'm getting very colloquial. I don't think he should get a cookie for doing what he says he does with text. But I think he was I really do think Gorsuch really didn't have a choice. And I think he's more committed to that approach to interpreting statutes than he was to this. And the reality is statutes can be repealed. They can be changed. So, if you get enough people riled up, they take over the Senate, they take over the House, you can, very sadly, and, to be, again, the Debbie Downer of all Debbie Downers, Title VII can be repealed.
Yeah. And it's a cliche, but elections matter, especially Senate elections. When you talk about the long game, it occurs to me, Kimberly, sometimes it's really, really hard, almost impossible, unless you spend all day with your students or all day in your law books, or you've actually clerked in the Ninth Circuit. Sometimes it's really hard to see past the headlines and see what the long game is. And other times it's a little bit easier. Like if you pay a little bit of attention to the court, maybe even not a lot, you've noticed in the last couple of years, there's these new cases coming down the pike. They're sort of about the same old issues. They're about like, they're about gay rights or they're about Obamacare and contraception, but there's a whole different spin on it. Now they're about religious freedom. All of a sudden, these cases are being framed in terms of not a woman's right to contraception under Obamacare or a gay person's right to have the cake shop make a cake for their wedding. In the case of Colorado, that was a case. But they're being framed in terms of the cake shop owner's right not to violate his religious principles by being forced to make the cake, or the company's right. There's a case in front of the court now that we haven't don't even have an opinion yet. A company's right to say this is a violation of my First Amendment religious freedom to have to give Plan B, have to pay for Plan B contraceptives for my employees because Obamacare says I have to. It's like the same old culture war, but a totally different legal framing of it. And when you look at
Hmm.
it that way, you say, no, wait a second. Now I've seen the matrix. Now I can see through the code. And now the law, I can sort of see a long game there. It's a totally different framing of the old debate when it's about religious freedom. And that's totally happening.
Yeah, again, I said I kind of gave myself homework. One way I was trying to put this into words because I was like, it's not victim blaming, right? It's a step further. It's like I'm a victim of religious discrimination if I'm not permitted to discriminate. And and that's actually not all that new. You've seen that in the context of I'm a victim of race discrimination if a civil rights statute impacts my employer and asks them to, make sure they don't exclude African Americans. You've seen it in race-based affirmative action. Abigail Fisher. I'm a victim of race discrimination because the University of Texas at Austin has a minuscule racial component that doesn't even really impact who goes, because if you go to University of Texas at Austin, it's not like it's, majority black or majority non-white. There's still plenty of whites being admitted. So it is actually very explicitly when folks started doing this, and it dates me, but it dates me in a way, but it also dates back that one thing about the racial justice civil rights movement of the 1950s, 1960s is after it, our society, in a really good way, has embraced the idea of that was good. Like Jim Crow segregation, bad. um, we don't do that anymore. But then there was a very quick and immediate twist and co-option of the language of civil rights. Bork very quickly said, well, Title II of the Civil Rights Act of 1964, Bork is the nominee to the Supreme Court who didn't get there because he was one of the last to actually be honest about what he thought the Constitution meant. Now,
Yeah, people learn their lesson after
Joe
that.
Biden. Now they do just, and really talk about someone who did a good job. We're talking about Chief Justice Roberts. He gave wonderful constitutional law lectures that made him seem just completely wonderful and never answered anything directly about what do you think it means.
Mm-hmm.
I just go about this rights. But Bork said that Title II of the Civil Rights Act of 1964, which is the public accommodation statute, is the statute still something that could be repealed. And getting a little political, Rand Paul said it should be appealed. If you're a libertarian, I shouldn't have to let I shouldn't have to let people in my restaurant who I don't want to associate with. Bork made that claim back then that it violates the civil rights of racist whites who own lunch counters to make them associate with black people. So I want to say it is both old and it is actually older than it may seem. That it is literally taking the inclusion of a group and civil rights for one group and saying that it is discrimination against another group. And so it has been accepted not because it's based on precedent. I mean, all we have is like the Equal Protection Clause, or all we have is the statutes themselves, or even the religious freedom laws, religious liberty. None of them say any of that. But there is a willingness, I think, in the American mindset to go, well, if if enough people say this intervention to protect or include a group that's historically been excluded, if enough people label that discrimination, there's a willingness, and it's become part of, I think, of our American psyche to go quickly to that. Oh, well, yeah, it is discrimination. And that
and there is
labeling of
and there is this
discrimination.
effort. I agree with you when it comes to building. I don't accuse John Roberts of this. It's not really his role. People bring cases before the court. There is definitely this long game political effort to bring religious discrimination into the equal rights lexicon. It happens in politics all the time, right? It's part of
And it
grievance
happens
politics.
in,
It's part of the
but it's
Fox
part of
News
their
brand of
opinions too.
politics.
But this is where
Hmm.
me being the geek will come in. It's also in their opinions. So two things are going on. One, there's impact litigators who say we are modeling ourselves on Charles Hamilton Houston and Thurgood Marshall when they overturned Plessy versus Ferguson. We got an agenda. So we don't get all these Second Amendment cases because individual people just wake up in the morning. There are lawyers out there who they wake up in the morning, they come up with these cases. The same with the abortion regulation cases. The legislatures have to pass these laws that they know violate Roe v. Wade, and then they got to get there. But also the court gets to pick and choose which cases they hear. But also the court writes things in these opinions. And while I don't know what blog they go to, when I read more modern Supreme Court opinions, maybe that's why they're 139 pages long, right? There, if you pull out certain paragraphs and post them on Facebook for the right group, I would be up in arms if I were getting the things in my box, because in Obergefell versus Hodges, the same-sex marriage case, the things that Justice Roberts and Alito wrote in dissent were incendiary. They were saying that Kennedy thought people who were religious were bigots, and they were invitations to bring these kinds of lawsuits. Kennedy himself had language in Obergefell versus Hodges that said, well, reasonable people can disagree. And to me, the expert is like, you don't usually put that in. Like, why
Mm.
is there even a couple of paragraphs about that? You're interpreting the Equal Protection Clause and the Due Process Clause. This is not about the religion cases. And pointing out that we don't have religious based regulations. I mean, you could have given that, but the extra language saying, but we really understand people feel strongly about this. And in the same sex marriage case, in the lead opinion, in the majority opinion, Kennedy invites those who disagree with the right he is deeming to be there to continue to try and convince their fellow Americans that it's wrong. And while I am not personally LGBTQ, I just would try and empathize and put myself in that position. I'm reading this opinion. First of all, it's not like Brown v. Board. It's not unanimous. It's already split. And then I get to the end of the lead opinion, and the justice writing it is inviting my fellow Americans to continue to convince the rest of America to to change this rule somehow. And so I think that the court has played a very aggressive role through its words in opening up space for this, because it could very well be that we had opinions that said this is just like when whites said the Bible says blacks and yellows and whatever they used to say, Malays need to be on different continents. I mean, there was ever in all those instances an assertion that it was from God and that it was religious, and that even permitting blacks in the workplace or blacks in a school or at the lunch counter, for goodness sake, that all those things were against beliefs. And that's where really, again, I'm getting more and more focused in looking at what that means for the future, because what
Hmm.
is going on in the religion clauses, I think, is on the trajectory to clash. And you're right, it's a very subtle way to accomplish. If you work for a religious institution, or it doesn't have to, it can be Hobby Lobby, right? It can just be a company. A company can say, I'm not going to give you contraceptive insurance benefits beliefs. And but yet African Americans can be murdered by the police, and that doesn't trigger heightened scrutiny, right? Like, we can't even get to that
Mm.
today, right? But when it comes to interpreting the Equal Protection Clause, they don't use originalism, pick and choose. I'm like, well, why don't you ever talk about what that provision was intended for, right? It was at the end of the Civil War. It was the Reconstruction, the radical Republicans who were trying to give rights to African Americans. But somehow Abigail Fisher gets, strict scrutiny, and it's like, I don't think that's what they were thinking about after the Civil War. So I think it doesn't take that much for the average person if you kind of know where to look, right? If you know where to look, you can kind of see, even if it's a very subtle boil. What is great about this time and moment is there's so much access. We don't have like just the case books and some dusty old shelves in a law library. In
Yeah.
the cases,
Well, I was
everybody
going to
can,
say,
download them.
yeah, I was going to say, Kimberly, before we go, even to me, a total non-expert, but just somebody who picks up a history book once in a while, um, just like the most casual reading of the defenses of slavery, the most casual reading of defenses of Jim Crow and segregation, at first, before those arguments were knocked down, were almost uniformly religious. It was white people's religious freedom and their religious imperatives that meant you couldn't mess with slavery, that meant you couldn't mess with their way of life in the South. They were defending the natural God-given right of things. And you don't have to be a law expert to remember and read about those arguments. They were entirely religious freedom based even back then, and it's fascinating to see that subtle politics of grievance working its way back into the arguments that that the project lawyers bring before the court. Well, we got to go. But before we do, I want to put one quick question to you. From the politics school, so it's a political question. Donald Trump twice now has put out lists. These are the people who I'm going to consider from this list to nominate for the Supreme Court. He did it before he was elected president. He says he's going to have a new list for his reelection because the right is so unified when it comes to their ability to pack the courts. Should Joe Biden do the same? Hey, everybody says liberals and Democrats are not fired up enough about how important the judiciary and the Supreme Court really is. Do you think Joe Biden should put out a list and say, these are the 20 people, these are the 20 women, the 20 black jurists, the 20 Latinas, the 20 judges. These are the 20 people that I'm going to pick from if you elect me president. Should he do it?
I love getting your questions
I
that's
love
completely outside my expertise, but my answer would be I don't think it's necessary. No. I would say no. I would say put out a list of the rulings that are the most important. I'd say put out a list of the freedoms that you will potentially lose. I'd help him write that list, right? I can tell you these are your freedoms that are at stake in the next 5 years under the Republican appointed. I would say think about if the law according to Justice Thomas and that's what happened with respect to Bork. Kennedy was very
Mhm.
successful in taking up Bork was interpreting the Constitution, and the People for American Way had an ad that said, "In Robert Bork's America, X X X happens." I think that's what you say in a court that gets one more Republican appointed, Federalist Society groomed Supreme Court justice. This is what that America looks like, and I think that could be a way that it doesn't become divisive and focused because there's no guarantee. I mean, Clarence Thomas is African American, right? He thinks he puts Roe v. Dred Scott in the same citation string, and I'm like, whoa, mind blow. I know he's not a fan of Dred Scott, so I don't know that identifying people based on their race and I mean, and I think the complexity of identifying people and how they interpret the Constitution is kind of built in. I know that Joe Biden, because I'm a student of it, being on that Senate Judiciary Committee, he knows what interpretations of the Constitution translate into your real world rights. And we've got a current court that wants to increase rights to carry assault weapons and be out in front of your house. And President tweeting pictures of that is pretty dumbfounding, right? Like those are weapons that historically Congress could say, well, no, we think that only military folks should have those or something like that. That Joe Biden knows that well enough that I think that kind of promise, the promise to keep us from losing more of our rights, and then just the big picture rights, like freedom. I just want to live in a free country, right? I don't want a tyrant in the White House. We didn't even get to all that, right? But that's what will be the next time. We've got a bunch of opinions about executive power and checks and balances, and all these other sub rights are not going to matter if we don't live in a country where we can even have this kind of conversation, right? Like if we start to live in a country like China or Russia, we just engage in very dangerous, probably
Well, I hope we get the
dangerous.
chance to do it again because there's so much more to talk about. Joe Biden, if you're in your basement and you're watching Vice.com, Kimberly West Falcon says, don't put out a list of jurists, put out a list of issues and tell people how your justices would be inclined to interpret the Constitution. Hey, Kimberly, I can't tell you how much I appreciate it. It's a great discussion. I hope you have a great 4th. I hope you have a little bit of time off. I want to thank you for joining us. Kimberly West Falcon is Loyola Law School professor, former clerk on the Ninth Circuit, former civil rights attorney. Kimberly, thanks again, and I hope we get a chance to do it again.
Sounds great, Todd. Have a good 4th yourself. Bye.
You too.